us for the 2015 Employment Law Series preview. We've got several people on the line with us today, and what I'm going to do to make it as informal as possible, I'm going to unmute your line so you can stop and ask me questions as we go along. I'm going to send you an audio pin. If you would just enter your audio pin on your phone, you'll be able to talk. Okay, looks like I've got one person that's talking. Linda, looks like I've got you. You can talk if you have any questions. But as I said earlier, this is David Whitaker with the Georgia Employers Association. We're partnering with Constantia Brooks Smith and Profit and the Georgia Employers Association to present the 2015 Employment Law Series. Constantia Brooks and Smith is one of the larger employment law firms in the nation. We've worked with them for many, many years, and they're a great firm to work with. Let's go ahead and just get started. Okay, some of you may have seen this slide before. It's used quite frequently. Matter of fact, I was in a workshop here recently, and one of the attorneys used this slide. But basically, what it tells you is that out of 10,000 employment lawsuits, the cumulative cost for a company defending a single lawsuit is $10,000. That's pretty expensive for most companies. It's not in the budget. If it gets resolved by summary judgment and other pretrial rulings, which summary judgment is basically letting the judge make the decision, about 2,400 resolved that way with a cost of about $100,000. And you go on, if it goes to trial, it's going to cost around $175,000. By the end of the trial, trials are won by plaintiffs around $250,000, and the plaintiff victories survive appeal around $300,000. So you can see this is pretty expensive. What we're doing here is being proactive. This is pretty expensive times to deal with. Okay, this is from the EEOC website. Tiny's Organic settles EEOC pregnancy discrimination suit for $17,500. Pregnancy discrimination is a big issue right now. Magnolia Place Personal Care Home to pay $20,000 settle EEOC pregnancy discrimination lawsuit. As I mentioned earlier, pregnancy discrimination is a pretty big issue right now. Red Lobster restaurants will pay $160,000 to settle EEOC sexual harassment lawsuit. Sexual harassment also are big issues as well. Liberty Chrysler dealership sued by EEOC for disability discrimination. I didn't get the numbers on that one, but it's up in the thousands of dollars or tens of thousands of dollars. Newport News Industrial Corporation agrees to pay $65,000 in the EEOC retaliation lawsuit. That is not in most people's budget. Appeals court affirms jury verdict of over $1.5 million in EEOC sexual harassment and retaliation lawsuit against Newbury Logistics. I think that was, once again, within the tens of thousands of dollars. Now, what we're going to do is talk about the workshop itself and being proactive, so you don't get hit with those kind of costs. What will the workshop cost? Well, for member companies, $125 per individual workshop. Non-members, $175 per individual workshop. You register for all five. For 5 workshops, members $550, the non-members $750. If anyone wants to register for all 5 workshops, they can attend all 7 workshops at that price. We're not going to charge you extra if you want to come to additional workshops. You compare that to the cost of the lawsuit in the previous slide. You can send several people to these workshops of what one lawsuit would cost you. I know when I was with the company I was with earlier, before I retired, we had 10 or 12 EEOC charges. We won all of them, but it probably cost tens of thousands of dollars to defend them. So the cost is associated. You're much more cost effective to be proactive. Where would the workshops be conducted? all of them will be conducted here in the Pickling Building, this 577 Mulberry Street on the 16th floor, Cherry Blossom Suite. All of them are from 9 to 12. They're all scheduled for Friday. Ample parking. The parking deck can validate the ticket. Directions provided if needed. So if anybody doesn't know where we're at, we can easily tell you how to get here. Workshop number 1, Introduction to and Basic Understanding of Human Resources Law. John Welton is going to be the one facilitating that particular workshop. And what's he going to cover? What does protected class mean, and how does this impact hiring decisions? First, you've got to know what you're looking for. What is protected? Not everything is protected. A detailed explanation of Title VII. Title VII is kind of the granddaddy of, it's actually Title VII of the Civil Rights Act of 1964, kind of the granddaddy of the Civil Rights legislation. It was implemented back when President Johnson was in office. There are other protected classes by law, such as age, disability, retaliation, genetic information. For example, I tell people that you can't fire me because I'm old, but you can fire me because I'm skinny. Skinny people are not protected. So, but for maybe you could fire somebody because they were left-handed. You didn't like left-handed people, but there's certain classes of people are protected. So, and what John will do will cover those protected classes, so you'll have a real good clue to be proactive. Overview of other employment laws, and for example, the Fair Labor Standards Act. That's a big law, the big issue that people can't follow. And of course, obviously, the examples of penalties and fines for non-compliance. Okay, workshop number 2, conducting accurate and legal internal investigations, a how-to guide. This is a big issue here, and what will be covered: how to handle harassment and other complaints by employees. What to look for. Once again, what to be on the lookout for. What people are going to be looking for if you file a discrimination charge. But then you want to protect the person who makes a complaint. You want to know how to interview the person who makes a complaint, what you can and cannot ask. All these are going to be covered in the workshop. Also will be covered general interview guidelines, common mistakes that employers make in doing investigations, fines, penalties, and additional costs for not doing it right. So once again, this is going to be a critical workshop if you're interested, if you're in human resources. Something that we don't think too much about a lot of times is workers' comp. Jason Logan is going to talk about cutting your workers' comp costs to how to reduce costs and common pitfalls to avoid. I know when I was in my previous job, we had an employee he was driving a dump truck, and all he did was just roll over in the ditch. We didn't even realize he was hurt. They ended up costing several $100,000 before it was over with. So there's big money there that sometimes you don't realize. And Jason's going to give an update on the legislative case law. He's going to talk about best practice of efficient return to work, top defenses of return to work claims. And the good thing about Jason being a workers' comp attorney, and also April Holloway, who works with him, they can talk about workers' comp and how it impacts the FMLA and also the ADA, Family Medical Leave Act, and the American with Disabilities Act, because they're all three tied together, or can be tied together. Proper use of the panel of physicians, having your panel of physicians right and being able to know when to use it and when not to use it, calculating the average weekly wage, and how workers' compensation can be a legal minefield if not administered correctly and can result in significant liability to the company. I mentioned earlier about the huge case that we had with my previous position. Workshop number 4, and of course, if y'all have ever heard Jeff Thompson present, you know he's probably one of the best presenters in the nation when it comes to employment law, effective in negotiating a discipline and discharge process, including policies, being ready advisory, including your handbook. Why you should have purpose of having clear discipline and discharge policies. avoiding wrongful discharge lawsuits, how does federal and state law impact discipline, discharge versus protected activity, replacing disciplination with positive discipline. One thing you find about the labor attorneys is, which can stand you, they want to add a positive portion to the workshop, and Jeff does a great job of that. Of course, obviously, the policies will be revised and included in your handbook. The way things have changed rapidly in the last several years, and so he will go over some of the things that you need to be aware of and look out for in your handbook. A big issue here, preventing sexual and other forms of harassment, what HR professionals and managers need to know. When I put managers in there, not just HR managers, but your managers as well. You may want to send some of your managers to this particular workshop. This will get you on the sexual harassment workshop. A sexual harassment lawsuit will get you on the front page of the newspaper very quickly. Most companies don't want to be on the front page in that respect. How employers can prevent expensive harassment charges and lawsuits, what you should include in your overall anti-harassment policy, training your managers and employees to report harassment, the impact of social networking on anti-harassment policies, and altering your anti-harassment efforts. Some states require training. Georgia does not necessarily require training for your managers and your supervisors, but it's highly recommended so they'll at least know what it is and how to prevent it. Workshop number 6, how the new ambush election regulations make it easier to unionize your employees. Mel Hayes is going to be doing that one. The NLRB just recently changed the way they do business in one respect, and that is they reduce the time frame for holding an election. And basically, when you have a union election, you want several weeks to prepare for it because the union is going in and is convinced a number of your employees they want to vote for the union, and they sign cards saying they would vote for the union, and so you're kind of behind the curve. Basically, what you want to be able to do is you want some time to go in and convince the employees they don't need a union, and then and so they reduce the time from 6 weeks to 2 to 3 weeks, which is going to make it very, very difficult. It's going to make the union and the campaigns much more difficult for the company. Mel's also going to go into the vital rules and how the changes will impact union campaigns, what you can and cannot do. The National Labor Relations decision in Purple Communications, which makes most current email policies illegal. Purple Communications was a company that did translations for disabled people, and they didn't feel like they were getting a fair shake, so they went in and changed the rules on them. So proactive steps you should take now to address these changes and help make sure you will remain union free. And of course, obviously, as I mentioned earlier, positive lessons in leadership, they generally cover those kinds of things as well. And then workshop number 7, Conquering FMLA, a basic class in administration of the leaves of absence. This is the one that we get a lot of questions about. And it's sometimes it's not a clear-cut answer. You just have to make an educated guess. You want as much education as you have in case it's not clear-cut. How to handle various types of employee leave, including FMLA, intermittent sick, doctor's excuses, etc. I don't know of a single company with over say 5 or 6 employees that doesn't have problems with someone who is going to be out too much or missing time. And what do you do about it? Do you discipline? When do you discipline? How often do you discipline? What do you discipline them for? Those kinds of things. Lisa's going to make that very clear. And update the latest FMLA regulations, tips reducing and scheduled over to absenteeism, overview of approval leave is a reasonable accommodation, best practices when terminating someone, but basically absenteeism, so basically she's going to cover those sorts of things. Looks like we got a question. Let's see if I can figure out how to... Okay, let's... Okay, somebody had, okay, I guess they maybe got their hand raised. Okay. Okay. We'll cover that in a little bit. Okay, who's going to be teaching the workshops? I mentioned John Welton. John does workshops for Constangy and for GEA. He's been here several years now. He's a graduate of Mercer University. Sarah Pfaff is also, she's our newest attorney here. She does a great job. She's taught several courses for us. Jason Logan's going to do the one on workers' comp. He, back several years ago, Constangy didn't even have a workers' comp practice, and he's built it up to a huge practice now, one of the largest workers' comp firms in Georgia. Lisa Peters, I mentioned her earlier. She's going to be doing the one on the leaves, and she does a great job. She covers everything about leaves and FMLA and ADA and everything you're going to need to know about that. Jonathan Martin, I call Jonathan Martin's rock star. He's the one doing the program on sexual harassment. He does a great job as well. Of course, and you got Mel Hayes doing the one on the NLRB, and then Jeff Thompson doing the one on terminations. So, if anybody, if you enter your audio PIN number, I can unmute you so you'll be able to talk. Otherwise, you can type a question in. Would anybody have any questions? Okay. I don't see any questions off the top of my head. Okay, would you like to type some questions in? Well, why not? Let me give you my my phone number. It's 478-722-8282. 478-722-8282. My email address is david@georgiaemployers.org. David@georgiaemployers.org. So if you have any questions, please feel free to contact me at either email or phone. I'll be glad to talk to you more about the program. If anybody wants a copy of this PowerPoint, I'll be glad to send you a copy as well. Well, thank you for joining us today. I appreciate it very much, and please feel free to give me a call or email if we have any more questions. Thanks a lot. Take care. Bye-bye.